Probate is the application to the court for legal authority to enable you to deal with the deceased assets. If there's a will, then the application is for a grant of probate. If the person didn't have a will, then the application is for a grant of letters of administration. It very much depends on the size and complexity of the person's estate. If there are assets that need a grant of probate, then obviously we can advise you of this and make the application on your behalf. We would prepare all the application papers, including the inheritance tax return, and then we would arrange for you to attend before an independent solicitor to have the oath sworn. If you weren't acting with a solicitor, then you would need to make the application in person to the court, and this may involve attending an interview at the court. If someone dies intestate, then who can apply for the grant of letters of administration is determined by the rules of intestacy. So we'd have to look what family members there are when a person dies to determine who would make that application. And the intestacy rules also determine who would benefit from the deceased person's estate. It very much depends on the size and complexity of an estate as to whether you would want to use a solicitor or not. Obviously it's very time consuming being an executor. There is lots of information that needs to be gathered at the outset, including valuations of the property, valuations of any shares and bank accounts. If we were acting for you, then we would gather all this information and we would also arrange the valuations for you. Once we've got all of that information, we then prepare the forms and the oath that needs to be completed. Whereas if you haven't got a solicitor, you would need to do this yourself. If there's any inheritance tax to pay, then we also arrange for that to be paid from the deceased assets, and we ensure that any deadlines are met. So it eases the kind of responsibility and worry on the executor because we're taking that burden away from you.